Hello, everyone. I'm Michael Hunt. I am the Director of Title IX Services here at Texas Lutheran University. I'd like to welcome you to a Campus Safety Week presentation of After a Sexual Violence Report, What Happens Next? We are doing this, by the way, slightly different format than originally scheduled. This was meant to be a live presentation. Now we are recording it, and we'll have this available for people throughout the week. Hopefully it'll cut down on our question and answer time as we go through. But let's get going. First, before we get too far into this, this presentation will discuss sexual violence, sexual harassment, and other acts of sex and gender discrimination. If those things are triggering for you, please practice self-care or reach out to your support network as you need. Additionally, I've put a few numbers down on the screen for a local organization, the Guadalupe Valley Family Violence Shelter. We're going to talk about them as we go. Their contact information is there, as well as a national number for the RAIN network. And so if you are someone who could benefit from talking to someone or making use of those resources, I certainly encourage you to do so. A few objectives for tonight's presentation. I want you to know how to report. I want you to know how to report an allegation of sexual violence or harassment or other discrimination. I would like you to better understand the investigation process and the resolution process that the university uses. I'd like you to have a little bit better understanding of that. I'd like you to understand the supportive resources, supportive measures we call them sometimes, that are available to complainants. I'm going to define complainant here in a moment as well. And then finally, I'd like you to understand the rights and the options that each complainant has in the Title IX and sex and gender discrimination process. So first of all, in section 1, I want to talk just a moment about some of the people involved in this process, some of the definitions, because you may not be familiar with all the terms. And give you some examples of violations of Title IX and sex and gender discrimination. First of all, Title IX, I've mentioned it a few times already, it's the federal law that prohibits discrimination based upon sex. It's been in effect since 1972. There have been some recent changes from the Department of Education that have modified Title IX quite a bit. We will talk about those as we go. The person on the TLU campus who's in charge of overseeing the Title IX process is the Title IX coordinator. That is currently Christy Quiros, the Vice President and Dean of Students. The Deputy Title IX coordinators, there's 6 of them. They work under her, and I am one of them. We receive reports of allegations, and we conduct investigations. And then the unit that I work with is part of Student Life and Learning Title IX services. We conduct trainings and educational sessions like this, and also, as I mentioned, are involved in that investigation process. The Guadalupe Valley Family Violence Shelter is a local not-for-profit agency that deals with matters of sexual violence, dating and domestic violence. They are an outstanding resource, and I'm happy that we have them available here at TLU. One of those individuals that works there, we refer to as the advocate. Hannah Fisher-Klug is the advocate who's on campus 1 day a week. On Thursday, she's here. She's also available by phone, and there's a hotline where you can reach out to them 24/7 as well. We also have an advocacy coordinator here at TLU, and Leslie Flores, the person who arranged Campus Safety Week, is that person, and she coordinates the prevention and outreach programs. Like Hannah with GVFES, we are really fortunate to have Leslie in that role. She does an amazing job. Okay, a few other terms I want you to get a little comfortable with because they can be tricky. You're going to hear me say allegedly a lot tonight. And there's a reason. As investigators, we have to be unbiased and neutral, okay? We can't be seen to favor one side versus the other. And so when we say something allegedly happened, it's not that we don't believe someone that it happened or didn't happen. It's just part of that neutral, unbiased process. So you're going to hear me say that a lot, allegedly, and just understand it for what it's worth. It's a measure of being unbiased. Complainant. I've already mentioned complainant several times tonight. You may have heard it also referred to as victim or survivor. There are different terms that people prefer. But generally, we're talking about someone who has been discriminated against, and generally by the respondent. And the respondent is sort of the converse of that. That's the person who allegedly has discriminated against someone, in this case, the complainant. And you may have heard respondents referred to as responding party or alleged perpetrator in the past as well. Finally, sex and gender discrimination. You'll see that I abbreviated SGD throughout this presentation because it's a mouthful. Is any adverse action that restricts or prohibits an individual's opportunity for education or employment or any other activities based upon sex, gender, sexual orientation, or gender identity. It includes things like sexual harassment, sexual assault, dating violence, domestic violence. We put those under the relationship violence umbrella. Stalking, sexual exploitation, and there's other forms of discrimination as well. But first, I want to give you just a few examples of what reports look like that we receive for some of these different types of allegations. So these are examples of sexual harassment reports. Employee A sent me nude photos of themselves via text today while I was working. Okay, that's an example. Student B has texted me every night this week to come over to their apartment late at night to hook up. I've repeatedly told student B I'm not interested. Another example. Employee C just sits and stares at me the entire time I'm swimming laps in the pool. It makes me feel uncomfortable. My friend has asked employee C to stop, but they don't. It makes me want to stop swimming. Finally, student D was telling anti-gay jokes during our group meeting today in the library, even though they know that group member student E identifies as gay. We all asked student D to stop, but they laughed it off like it wasn't a big deal. It's really impacting the group getting our project done. Okay, so those are all 4 examples, pretty real life type examples of what a sexual harassment report might look like. Here's a few sexual assault reports. Student A and I were at a party together Saturday. I got really drunk and blacked out. I remember dancing, and then the next thing I remember, my clothes were on the floor in student A's bedroom, and student A was having sex with me, or touching me, or performing oral sex on me. Okay, that's a fairly common type of report that we receive. Employee B came up behind me while I was standing at the printer and grabbed my crotch, grabbed my breast. Again, fairly not uncommon type of sexual assault in that case. Student C is my partner, and we've been sexually active with each other for 2 years. Last night we were having consensual sex, and I told student C that I wanted to stop. Student C wouldn't stop until they were finished. Okay, that's an example of 2 people who were having a consensual activity, and then one person went too far and committed potentially, allegedly, a sexual assault. Okay, here's some examples of dating violence, relationship violence, dating violence, domestic violence. I've been dating student A for 2 weeks. Last night we got into an argument because they called me stupid and ugly. I yelled back at student A, and eventually I slapped them. Okay, there's one example. Employee B tried to break up with their partner, employee C, last weekend. Employee C got really upset and broke employee B's phone, screaming, "I know you were seeing someone else, and I'll never let you go." My roommate, student D, came home falling down drunk Friday night. When I tried to help student D get to their bedroom, student D got mad and shoved me hard against the wall and yelled in my face that they didn't need my help. So although we think of relationship violence, dating violence, we think of it as with a partner, with a romantic partner or a sexual partner. It can also be a domestic partner, somebody that you live with. So in this case, 2 roommates who had a violent encounter would qualify as domestic violence. Finally, a couple examples of stalking. Student A and I broke up 2 months ago. He or she texts me repeatedly every day and calls me late at night and hangs up. Now student A has started waiting for me outside of my classes. I've told student A to stop contacting me, but he or she won't stop. Pretty typical stalking report. Student B and I were friends until they told me that they had feelings for me. Student B got upset and started blowing me up on Messenger. I eventually blocked student B on all social media. Now student B has created a number of fake accounts and keeps trying to add or follow me until I block those accounts too. Student B doesn't identify themselves, but I know it's them. It's really upsetting me and I'm worried about what will happen next. Okay, so those are all examples of reports that again, are fairly common in the Title IX world. None of those were actual reports that we've received, but there's some elements of truth to all of them. And so we're going to move on now then to section 2. Section 2 is how to report. I know the name of the session is after a report, but I really want to make sure everybody understands how to do this. So there are 4 ways that you can report a Title IX or sex and gender discrimination violation. One is simply by phone. You can call the Campus Conduct Hotline. That number is 866-943-5787. It's on your screen. That's available to you 24 hours a day, 7 days a week. It will permit anonymous reports. And so that's one way. The second way is to go to the portal, and you can follow the tabs that I've listed there. You can go to My TLU, go to the Public tab, File a Complaint tab, Incident Reporting Form tab, or you can simply go to this link, my.tlu.edu/TIX report. And that is also a way to report. It's available 24 hours a day, 7 days a week, and also permits anonymous reports. The third way, and I think this is the one that I would prefer people report, it's the most direct, is to report either in person or email or by telephone to the Title IX coordinator, one of the deputy Title IX coordinators, or the director of Title IX services. That's me. The general email you can email to is Title9, Title IX @tlu.edu, or you can send any of us an email. You can see all of the emails of the coordinators are there, the phone numbers are there. Christy Quiros, you can see on the far left, is the Title IX coordinator. There are 6 deputy coordinators underneath her, and you can contact any of us. So even though it says Kyle Witch is the deputy Title IX coordinator for students, if you're a student, you don't have to report just to Kyle. You could report to Dean Quiros, you could report to me, you could report to Dave Lagore, anyone that you would like to report to. Same thing, staff and faculty don't have to report to the staff or faculty coordinators either. And finally, the fourth way that you can report at TLU is simply to tell any other employee on campus, besides the deputy Title IX coordinators or the Title IX coordinator. Texas state law requires that all university employees report any information that they receive regarding a violation. So you can tell a faculty member, you can tell a staff member, you can even tell an RA or a student employee. They are all required to report. Now, would I be more comfortable if you reported directly to the Title IX team? Yes, I would. But technically, that is a way you can report as well, and they are required to report that on to us. So those are the 4 ways that you can report. I really want to make sure everyone who sees this really understands that. That's just got to be something that everybody just knows and doesn't have to even think about. They just know how to do it. Send me an email. That's the simplest way. Okay, section 3, we'll talk about the investigation process. There are 3 main phases that I want to cover in the investigation process. The first is called preliminary investigation. And once my unit receives a report, we're gonna do a few things. First, we're gonna reach out and speak to the involved parties. We're gonna offer supportive measures, and I'm gonna talk in a minute what that includes. We're gonna get some preliminary statements from the complainant and the respondent. We're gonna assess if any allegations, if proven, would violate university policy. Sometimes we get reports that have nothing to do with sex and gender discrimination or sexual violence, have nothing to do with our area at all. They just, sometimes people send a report because they think they're supposed to. Sometimes they just do it mistakenly. Sometimes they just aren't sure what would fall under our area. So we're going to assess that as well. And then finally, we're going to determine the appropriate investigation process to be used. And there's really two different types of processes. There's Title IX versus the university ERP process. I'll explain that in a moment. And then the formal versus the informal process. So two different groups of two, I suppose. The Title IX versus the university process. So Title IX, what falls under Title IX is very strictly defined by the federal government. In fact, we got new regulations that came out in May of this year, which changed significantly the definition of what falls under Title IX. But if an allegation does meet that new requirement, we're going to investigate under Title IX. Okay, that's the default. If it doesn't fall under that category, we're going to investigate anyway, but we're going to do it under the university's own policies. And we call that the ERP, the Equity Resolution Plan, or ERP, is the university's policies against sex and gender discrimination or sexual violence. Under the Title IX process, a complainant must request a formal investigation in writing. So that's one difference in the processes. Otherwise, the investigation is slightly different, but mostly the same. But there are differences in the resolution process, which comes at the end. We'll talk about that in the next section. Also, a process can be formal versus informal. A formal process is one that's going to end up in a disciplinary outcome, such as suspension, expulsion, termination. We'll talk about some of the other possible ones here in a moment. But also, there's also an informal process as well. And that generally is going to result in more educational outcomes. Disciplinary ones are still available, but things like training or counseling, maybe some community service, read some articles, write some essays about how you impacted others, things like that. More of an educational outcome. Also, sometimes when a complainant only wants supportive measures, and I know I haven't defined that yet, we will in a moment, but if that's all they want, we can sometimes go through an informal process. And then the respondent must accept responsibility in the informal. And so if we have a situation where both parties agree that they want to do this, the respondent says, yeah, you know what, I did that. I shouldn't have done that, I did that. Then the informal makes sense to use. Okay, so I've mentioned a couple times this new definition of Title IX sexual harassment that the federal government gave us here in May. It covers three prongs. There's three prongs to it. First, quid pro quo harassment by a school employee. So quid pro quo basically means give something to get something. So if a teaching assistant said, told a student, I'll give you an A in the class if you go out on a date with me, okay? That's an example of quid pro quo, giving a grade in order to get a date kind of thing. Second tier is unwelcome conduct that is so severe, pervasive, and objectively offensive that it denies the complainant educational access. That's the second prong. And the third prong is any sexual violence. So sexual assault, stalking, dating violence, domestic violence, all fall under the new federal definition of Title IX. In addition, allegations to meet Title IX must occur in the US. So an allegation that occurred on a study abroad trip would not fall under Title IX, but would still fall under the university's ERP investigation process. It must occur within the scope of an educational program or activity, and it must include a complainant who is still involved in the university, so either employed by the university or attending school at the university. So there's that's a limiting factor because in the other process, an alumni can come back and file a report, maybe a year or two after they graduate. That's no longer available under Title IX. Okay, so once we are out of preliminary investigation or pre-investigation, we are now into the investigation phase. The first thing we're going to do is we're going to issue a notice of complaint or notice of allegations to each party. And there's a number of required legal elements that we have to include in that. That's going to tell them what the charges are, what the potential outcomes are, and what their options are. We're going to meet with each party individually, so they won't meet together. They'll never be in the same room. But we'll meet with them individually, and we're going to ask questions of them. They can have advisors present if they would like. We're also going to meet with any witnesses that we may have identified or they may have identified for us. And we may end up meeting more than one time with each of the parties. The parties are going to have an opportunity to tell their stories, present witnesses or evidence to us, and also give us questions to ask of the other party. That's also acceptable. And we're going to collect evidence. Evidence could be text messages, it could be social media posts, it could be voicemails, it could be photos, all the way up to including a SANE exam, which is an exam that a sexual assault victim might have after the assault, sexual assault or sexual violence. So all of that comprises evidence that we can collect and be part of that investigation process. Following the investigation, once we conclude that, we're going to write a report. It's going to include all the meeting notes, all the statements that the parties provide, all the evidence we collect, the timelines of everything. And then depending on the process, we're either going to analyze that information and make a suggestion of whether or not we think the respondent was responsible for those allegations, except for in the Title IX, formal Title IX process. In that process, we simply present the information to the hearing panel and they make the final decision. We don't even have a suggestion in it as investigators. Each party is going to have access to that report. So the respondent and the complainant will each have access to that report. Nobody else will. So they'll be able to see all the meeting notes, all the statements, all the evidence of all of the other parties, the witnesses, the complainant, the respondent. They'll get to see all that information. Not the witnesses. The witnesses won't get to see it, but the complainant respondent will get to see the witnesses' information. I said that badly. And then finally, each party will have the opportunity to request the Title IX coordinator to look at that investigation report and say it was adequately done, or it needs a little bit more work, or you didn't interview this person, why not? Or you need to go back and do a little bit more work. So each party has that option as well. Okay, so that'll wrap up the investigation process section. And again, because of how we're doing this today, no questions or answers at the ends of these sections, but that's okay. We're moving on to section 4, which is the resolution and appeal process. So after the investigation is complete, if the investigators believe that the respondent is responsible, then the process moves on to the resolution phase. Now, I have an asterisk there, and the reason not why I do is because, as I mentioned before, if it's the Title IX formal process, the investigators won't make a suggestion on whether or not they believe, there's a responsible respondent or not. It simply goes straight to resolution. Now, if we're talking about informal resolution, and that's pretty similar whether we're in the Title IX process or the ERP process, then we're not going to a hearing or anything like that. We're likely either going to have supportive measures only, and again, we're going to talk a little bit more about those in a minute. That alternative resolution process that I talked about, which is generally educational type outcomes, or a situation where the respondent has accepted responsibility. And again, both parties must agree to that process in advance. The investigators have to agree and sign off as well. And at any point, if any of the parties change their mind, they can end the informal process and move to a formal process. Then the resolution process, when you're in the formal resolution, if we're in the ERP, which again is the university's rules, there's really two things that could happen. We could have a disciplinary hearing panel with 4 individuals who are faculty and staff members, or there could be an administrative hearing with a single decision maker. And that's usually the vice president of the appropriate area. So if we're talking about a complaint with 2 students, student complainant, student respondent, then the vice president for student life and learning would be an appropriate decision maker. okay? If we're talking about, you know, a student complainant and an employee respondent or two employees, then the vice president for academic affairs, the provost, might be the appropriate person if the employee is a faculty member. Or if the employee is a staff person, then the vice president for administration or the vice president of finance might be the appropriate VP in that situation. So it just depends. And then in the Title IX formal resolution, we talked about this before a couple times. It's really a unique process. It is a live four-person hearing panel no matter what, okay? So there's no other options. It's just a live panel, hearing panel. And there will be mandatory advisors. So each party has to have an advisor. If they don't have an advisor, we'll appoint one for them, who will conduct cross-examination of the other parties in that hearing process. And so that is a really unique process. It's brand new. It was part of the new Title IX regulations that passed in May. And so it'll be interesting to see how that plays out. But it is a brand new format in that, with that cross-examination. Okay, so the hearing panel or the administrator, they meet, they make a decision. There's an appeal process that follows that. It's only for the formal resolution, first of all. So, you know, only formal, not informal. Either party may appeal. So if either party is unhappy with either the decision or perhaps the disciplinary sanction or outcome, they may appeal that as well. There are specific criteria that the appeal must fall under. If it doesn't fall under those, then it's not eligible for appeal. And then there will be a separate appeal panel, I think a 3-person panel that will rule on the appeal itself. So the appeal process follows the resolution process. And finally, the potential outcomes, we mentioned a few of these earlier. It could be anything from a warning or a reprimand to required counseling, training, it could be probation, could be suspension, expulsion, termination. There's actually a pretty long laundry list of potential outcomes. And so those are, I think, the most common. Okay, so that'll wrap up the resolution and appeal process. And that'll take us on to section 5, which is supportive measures. I've been talking about these all night, and now I'm finally going to tell you what they are. So there are 2 times where supportive measures can be used. One is in the preliminary investigation phase, and one is in the post investigation or the resolution phase. The most common supportive measure is the no contact order. And that's simply a document that says there's to be no communication between the parties, either directly by in-person or phone calls or texts or social media, indirectly or through a third party. So if there's a mutual friend, one party can't go to the mutual friend and say, hey, tell so-and-so that I said this. That's not allowed. And it lasts indefinitely unless you know, each party requests the Title IX coordinator to terminate it. Another supportive measure that's available are confidential resources. Those are employees that you can speak to confidentially who are not going to report the information that you share with them, except in some very rare legal circumstances such as minors or elders or imminent danger. Those are the only 3 exceptions to that rule. We've mentioned one of those confidential employees already. That's Hannah with the Guadalupe Valley Family Violence Shelter. She's the advocate that's on campus. She's a confidential resource. The campus pastor will be a confidential resource when we fill that position. The health services professionals on campus are. That includes the people who work in the health center and athletics trainers as well. And then the counselors in the counseling center. So all of those people you can speak with confidentially, and it will not be reported to law enforcement or to Title IX or anyone else. So that's a second supportive measure. We can do class or work schedule changes. If you're sharing a class with someone or work in the same place with someone, we can make some changes. We can also change residence hall rooms or work locations sometimes if requested. We can provide on-campus escorts. So moving around campus, not feeling safe, we can provide someone to be with you, to walk with you, between classes or maybe to dinner. We can request that UPD conduct frequent security patrols of your area, more frequent than they do. And then we can also, and this is rare that we do this, but it is there. We can issue a no trespass order or temporarily remove somebody from campus if we feel like they are an extreme danger or threat to you or to themselves or to the campus community as a whole. We can also help with reporting. We can assist you, give you the resources to know where to report if you would like to make a report to law enforcement. And they can also do temporary restraining orders through the county government as well. Some other measures that are available are you can drop classes, you can take incompletes, or you can even suspend your enrollment without any penalty. Both parties can do that. And yes, supportive measures are available to both parties. So it's not just complainants that get these options. As we mentioned earlier, it's an unbiased, neutral process. So we don't go in assuming that, again, one party is telling the truth, one party's not, one party is innocent, one party's guilty. We're not, we don't do any of that. We are neutral and unbiased. And so part of that is making sure that each party gets access to support because they're both our students or both our employees or, whatever the mix is. And then part of the new Title IX regulations from May are that supportive measures cannot be unduly burdensome or punitive to one party over the other. And so that's a little tricky because if you're having to move people out of classes and you're only moving one, isn't that burdensome on that person? Yes. Is it unduly? Maybe, maybe not. I don't know. So, so that's a little bit tricky, but that's part of the new Title IX regs as well. And then supportive measures are available at any time. So even if the complainant doesn't want to pursue an investigation or doesn't participate in an investigation, those supportive measures are still available. Okay, and so the other situation where supportive measures can come into play is, again, post-resolution. So we've got a finding now, and there's some long-term supportive measures that can be imposed. Again, that no contact order is probably going to go through till both parties are no longer at the university. It's probably going to extend all the way through that time. Sometimes a respondent can be suspended until a complainant finishes. Complainant graduates. I've seen that before. That's a possibility. We can remove people from campus housing at that point. The regulation that says we can no longer be burdensome or punitive, that does not apply when we're post-resolution. If someone is found responsible for a violation, then the supportive measures can be punitive. We can still provide on-campus escorts. We can still do security patrols. Counseling is still available post-resolution as well. And so that's it for supportive measures. And now I want to go to section 6. This is our last section. We're getting there. This is complainant rights and options. So these are the rights that a complainant has in our process. First, you have the right to file a report with the university, Title IX services. You have a right to file a report with us, and or could be both, could be neither, could be one or the other, law enforcement. So it could be university PD, could be Seguin PD, and you also have the right to have that report taken seriously and acted upon by trained professionals. You have the right to share as much of your story as you like, or not to share it at all. You have the right to participate in the process as much as you'd like, or as little as you'd like. And you have the right to share your story in the format in which you are most comfortable. So that might be in person, that might be by a written statement, that might be by phone call only, that might be by a video conference, whatever it is that makes you the most comfortable in the process. So I do have a couple asterisks there, and that's just to remind you that although you do have the right not to participate or to participate as little as you want, it might hinder our ability to respond and investigate. We may not be able to do that fully without your participation. You also have the right to request that no investigation take place at all. The Title IX coordinator will make that assessment. They may or may not honor that request, especially if she believes that the university community at large might be at risk, might be a safety risk. You have the right to receive supportive measures at any point, regardless if you participate in an investigation. You have the right to refile a report or request an investigation at a later time. So you might say, no, I don't want an investigation now, but in a year or two, you come back and say, you know what, I would like an investigation now. That is allowed. There's no statute of limitations except for those Title IX formal regulations, which say that you have to be enrolled or employed at the university. You have the right to have a support person or advisor present in all meetings and hearings. If that's the case, we're going to ask them to sign or ask you to sign a FERPA privacy release so that we can talk about private information in front of them. And that's because we're going to maintain your privacy to the greatest extent possible. You have that right. And we will only disclose information, your name, you know, the allegation, where, when, all that kind of stuff, to the investigators, the administrators who are necessary to either, you know, give you the supportive measures or to investigate or to do the resolution process. We would reveal to law enforcement if you decided to pursue a criminal investigation. If they asked for us, we would be able to do that. Healthcare officials, if there was some sort of emergency that we needed to reveal your private information, we would. And then the other parties that are involved in the process. So we've got to, you know, give all the information that we have to the, you know, to the respondent. We've got to give all the information to the complainant. The witnesses don't get all that information, but they do, you know, will need to know maybe your name to say, hey, did you see so-and-so with so-and-so at this party? That type of thing. Okay, so we'll go from rights to options. You have a number of options in our process. The first one is you can request that no investigation take place at all. We just kind of mentioned that, I know. And if that's approved by the Title IX coordinator, if that request is approved, we'll dismiss that case. But again, it can be reopened at any time down the road. We'll keep an investigation file open. You know, we'll still have that information that we got at the time. We can still use that, you know, a year or two later. And of course, supportive measures always available. You have the option to have an investigation take place, but not to participate. We call that a reluctant complainant. And again, this may limit the university's ability to respond or investigate fully. However, I have seen cases where we were able to complete an investigation with a reluctant complainant. A situation maybe where, you know, there's 20 pages of text in which somebody, you know, says horrible, terrible things to someone. They don't necessarily need to testify to that. We can read the text messages and get that information. So that occasionally can work. You have the option to initially participate in the investigation, but to change your mind during the process. And that could look at a couple different ways. You could start off in an informal process and then change your mind to go formal later on. Or you could, you know, choose to initially be in the process, but then, you know, midway through, you're just like, I'm done. I can't do this anymore. This is too stressful. This is too much. And in that case, you know, the case might be dismissed, or we might continue on with you as a reluctant complainant. You have the option to request an informal resolution process. Again, all parties must agree, respondent, complainant, and the investigators. You have the right to change your mind at any point. Generally speaking, we won't use informal resolution for sexual violence cases, sexual assault, stalking, that type of thing. We don't normally do that. The new Title IX regs a little bit open the door for that. It's a little bit of a gray area now. So, you know, it might be something that's possible in the future, but generally speaking, we don't like to use informal and sexual violence cases. You have the option to request supportive measures only. So I don't want this investigated. I don't want anyone getting in trouble. I don't want this being a record. I just, you know, I want a no contact order. I don't want to be in the class with them anymore. You know, if you can do that for me, then I'm good. So that does happen. And then finally, you have the option to fully participate in a formal investigation and resolution process. I'll tell you that generally takes about 2 to 3 months to complete the entire process from beginning to end. There are some time requirements that we build into that the federal government has built in that we have to honor. I will tell you that the process is stressful. It is. We're going to encourage you. We're going to help you connect with some support resources, but we're going to encourage you to lean on those support, that support network that you may have, including an advisor. We really believe that that's an important tool, as well as an advocate. We will frequently update you as to what the next steps are on the process. You're not going to have to worry about what's next, what's going on. We're going to keep giving you updates. We're going to be in touch with you. At no point will you be required to sit in the same room with the other party, the respondent, at any point. So not in the investigation, not in the hearing. We can separate you, put you in different rooms. We can do, video conferencing. If you request not to be in the same room, we will not put you in the same room with that person. Yes, and so we have very strict rules regarding no contact orders and retaliations, and additional charges will be brought if a no contact order is broken, or if one party retaliates against the other one. We're going to have serious charges for that. And I have seen cases where the respondent was found not responsible for the initial charge of say, sexual harassment, but were found responsible for retaliation or violating a no contact order, and got severe sanctions for those, even though they weren't found responsible for the initial allegation. So we take that stuff very seriously, and we are going to enforce it very seriously. And I want you to know you can depend on that. The one thing I need to make sure everybody knows, and again, it's part of those new regs, but the new Title IX formal process does include live cross-examination by the respondent's advisor. Now, your advisor is also going to get a chance to cross-examine the respondent as well. And so, it is fair and balanced on both sides. But that is a new process that we're going to have to sort of work our way through and learn about. But it's important to know that if any party, and it could be a complainant, respondent, or a witness, if any party does not submit to cross-examination by the advisors, then none of their previous testimony can be used. So any statement you provided, any testimony that you gave us in a meeting in the investigation process, none of that can be considered in the final resolution if you don't submit to that cross-examination. So that is part of that process that I need to make sure you're aware of. All right, that is going to wrap us up on complainant rights and options. And that's basically going to wrap us up for tonight. Again, we hope that, well, more than hope, I demand that you know how to make a report of an allegation of sexual violence or sex and gender discrimination. It's so important to me that everybody on this campus knows how to do that. I hope that, in addition to that, you've learned a little bit about the investigation process, the resolution process, the supportive measures that are available, the rights, the options. We hope that you've gotten a little bit of information from that, and again, wish that this could have been more interactive, so we could have taken questions at this point, but that's just not how it worked out tonight. But I do thank you for watching this video, and hopefully you got something out of it here during Campus Safety Week. So thank you for your time. Thank you for your attention. Be safe out there, and reach out to us if there's ever anything that we can do for you. Okay, so thanks again, and I think I've got one more slide. There we go. That's your Title IX team. Feel free to reach out to any of us, and we'll do what we can for you. Okay, thanks everybody. Bye-bye.